Welcome. This is Professor Guerra Pujol from the University of Central Florida, and welcome to Legal and Ethical Environment of Business. In this set of lectures, we're talking about copyright law, and we just saw how broad copyright law is. The moment you create something that's original, and that can be expressed in a fixed and tangible medium of expression, you own the copyright to that work. And of course, if you were to go ahead and register that copyright with the United States Copyright Office, you'd have additional legal rights to help you enforce your copyright. Now, in this lecture, I want to talk about infringement, what constitutes infringement. And the main thing you need to know about infringement, two things. That there's two types of infringement, and there's some very important case law regarding infringement. So what I want to do is talk about the major types of infringement. Main type of infringement is what lawyers call direct infringement. This is when you, for example, if I were to read directly from the novel A Movable Feast, one of my favorite novels written by Ernest Hemingway, and if I were to read a substantial portion of this novella, I probably would be committing copyright infringement, right? I do not have the authorization to copy or perform any part of this work. And so I would be a direct infringer of Hemingway's Movable Feast novel. Now, the other major type of infringement, and this is very important in the business world, is what is often called contributory infringement or secondary infringement or indirect infringement. This is when I facilitate it, when I make it possible for someone else to commit infringement. And it's indirect infringement that I'd like to spend the rest of the lecture talking about, because there are some very important cases talking about the scope of indirect infringement. Perhaps the most important case in the history of our nation is the Sony Betamax case that was decided in 1984. Just to give you some background about this case, because many of you are much younger than I am, but when I was a young lad, Sony came out with the Betamax, a video cassette recorder. This would allow you to do what a DVR does today. It would allow you to record your favorite television shows. And Sony was one of the pioneers in developing this technology and commercializing it, making it available to the mass market. And so you can imagine, now today, by the way, when we think of a video cassette recorder, I don't know if you've ever seen one. It's very clumsy, you know, it's, you have to have these huge cassettes, and recording, you know, can be complicated. But at the time, this was a really revolutionary technology. And Sony and other companies started manufacturing and selling these VHS or video TV recorders. And people were recording their favorite shows or the news or movies on TV. Well, this posed a fascinating legal question involving indirect infringement. For example, the movie industry thought, and the TV industry, I should say as well, thought that this was a form of indirect infringement. Companies like Sony, by selling the Betamax technology, the video VHS recorder, was making it possible for consumers to infringe the copyrights of the Hollywood entertainment industry. And this case, as you can imagine, went all the way up to the Supreme Court. I mean, imagine if Sony were to be liable for the indirect infringement of every time a consumer recorded a TV show, right? That would, in essence, bankrupt, right, Sony. It would probably bring to an end the sale of video recorders. Now, notice this is a very important case for strategic reasons, because clearly the TV industry, the Hollywood movie industry, they could have sued the individual consumers who were, you know, recording shows on their Sony Betamax without authorization. But think about how expensive and complicated that would be, and also all the bad publicity that would generate if Hollywood were to begin suing, you know, individual homeowners and families, right, for recording shows at home. in the privacy of their home. So the TV industry decided, and Hollywood decided, we're going to sue Sony on the indirect infringement theory. Well, the case went up to the Supreme Court, and let me tell you, it was argued twice. And it was finally decided by a very narrow 5-4 majority. And the bottom line is that the Supreme Court said that this was not a form of indirect infringement. Although literally you could certainly make the case that it was, but the Supreme Court ultimately ruled for Sony. I want now to fast forward to the early 2000s, and I want to talk about Napster. Because the Napster case, though it never went up to the Supreme Court, the outcome was radically different. If you may recall, Napster, what it did, it was a peer-to-peer file sharing system where as soon as you signed on for Napster, you would have access to the digital music files of other Napster users. And those other Napster users would have access to your digital music files. So it's a peer-to-peer file sharing system. The federal courts, however, in that case ruled, and I should say this all began with a lawsuit brought by Metallica, the heavy metal band Metallica, and Dr. Dre. So both a hip hop, artist and heavy metal artists were livid. They were upset that people were downloading their music files on Napster without authorization. And so they brought a lawsuit, and then the recording industry, the Trade Association for the Recording Artists of America, also joined this lawsuit and brought their own lawsuit, alleging that Napster was engaged in copyright infringement. As you can imagine, Napster's argument was that to throw out the Sony Betamax case. And stare decisis precedent, right? The courts have to be bound by the Sony case. However, the lower federal courts drew a distinction, and they said that, look, Napster was engaged in a willful system of making it possible for users to infringe these copyrighted music files. Now, I myself don't think that those cases were decided correctly. I think there's a inconsistency between the Sony Betamax case and the Napster cases, and there's another case after Napster called the Grokster case. But one of the main differences between the Napster case and the Sony Betamax case, which was decided in the 1980s, whereas Napster was in the early 2000s, was that in between those two cases, Congress enacted something called the Digital Millennium Copyright Act. And what that law does, a very controversial law, but what the law does is it says, look, we're going to extend copyright protections to works that are posted on the internet. So the internet, copyright law will apply to the internet. However, the Digital Millennium Copyright Act that was enacted by Congress in 1998 does something very special. It says that the copyright owner, before they can enforce their copyrights on the internet for material posted on the internet, they must first send out what's called a takedown notice to the infringer. And then the infringer has the opportunity to voluntarily take down the copyrighted materials from the internet and then avoid legal liability. If and only if the material is not taken down, then the copyright owner is authorized to bring a lawsuit in federal court to enforce his or her copyrights. Now, the reason why this law is actually very important is that if you think about it, it puts the cost of enforcement on the copyright owner. And it explains the difference between Napster and Sony Betamax, and also I might add, going to the present day, Napster and YouTube. Think about YouTube. YouTube is very aggressive in taking down copyrighted materials. If YouTube receives a takedown notice from a copyright owner, it will generally take down the copyrighted material from their website. In the case of Napster, they did not follow any of these takedown notices that Dr. Dre and the Metallica heavy metal band sent them. They basically ignored the takedown notices, and that's why the court probably distinguished the Sony Betamax case in the Napster case. Well, now you have a big picture of infringement. Infringement is the unauthorized use of someone else's copyrighted materials. And indirect infringement is also covered under the copyright law and the cases interpreting the copyright law. Facilitating the infringement of copyrighted materials is also infringement. And now you know about the Digital Millennium Copyright Act, or the DMCA, which applies copyright law to the internet, but requires a takedown notice be sent to the infringer before a enforcement action can proceed. The last thing I want to talk about in the next video is fair use, because there's actually a huge and very important exception to copyright law, to copyright enforcement and infringement, and that is the fair use doctrine. This is probably one of the most important doctrines in intellectual property law, and we'll see it in our next short video lecture. Well, thank you for your time. Have a great day, and go Knights.